Good evening, ladies and gentlemen. We've got some decisions from Judge Gull, believe it or not. Hold on to your hats. It's a lot to listen to, so I'm going to do my best. Let's go. State of Indiana, Carroll County, State of Indiana versus Richard M. Allen. Order on Precipe for Transcript. This matter comes before the court on accused Precipe for Transcript, and the court, being duly advised in the premises, now finds that this motion should be granted in part. It is therefore ordered that the following hearings under the above captioned matter be transcribed. 1. The hearing held on November 22nd, 2022. 2. The testimony of Jerry Holman and Trooper Roland Purdy from the motion to dismiss hearing held on July 30th, 2024. 3. The testimony of Dr. Monica Walla, John Gallipo, Jerry Holman, Brian Harshman from the motion to suppress hearing held on July 31st, 2024. 4. The testimony of Jerry Holman, Trooper Roland Purdy, Pat Cicero, Don Perlmutter, and Chris Cecil from the motion in Limine, hearing held on August 1st, 2024. It's dated August 13th, 2024, signed by Special Judge Francis C. Gull, distribution Carroll County Prosecutor's Office, Baldwin Perry, and Wiley, PC. And next, State of Indiana versus Richard M. Mullen. Defendant's supplemental submission regarding state's motion in Limine. Comes now Defendant Richard M. Allen by Attorney Bradley A. Rosie, and respectfully requests that this court take judicial notice of the record of proceedings in this cause on November 22nd, 2022, in the Carroll Circuit Court. In support of said request, Defendant Allen states as follows. 1. On April 29, 2024, the State of Indiana filed a motion in Limine seeking to limit various forms of evidence in this cause. Specifically, paragraph 7 of said motion sought limitations on defendant's ability to introduce evidence of third-party culpability regarding the following individuals and or subject matter. A. Odinism. B. Cult or ritualistic killing. C. Brad Holder. D. Patrick Westfall. E. Johnny Messer. F. Elvis Fields. G. Ned Smith. H. Rod Abrams. I. Kagan Klein. J. Jerry Klein. K. Ron Logan. 2. The state's motion in Limine sought to further restrict defendant's Sixth Amendment right to present his defense by way of limiting investigative records generated by former police officer Todd Click and geofencing records generated by law enforcement investigators. 3. On or about August 1st, 2024, the parties appeared in the Carroll Circuit Court, at which time both sides introduced evidence in favor of their positions regarding third-party culpability. The court took the issues surrounding third-party culpability evidence under advisement. As of the date of this motion, no order has been issued in this regard. 4. The defense requests that this court take judicial notice of the record of proceedings held on November 22, 2022, and attached hereto as Exhibit A. One of the primary issues addressed at the November 22, 2022 hearing was the state's request to maintain confidentiality of the probable cause affidavit, charging information, and other investigative records. 5. At different times during the hearing, the State of Indiana, by Prosecutor Nicholas McClellan, spoke the following words as it relates to the potential for third-party culpability. Quote, "This is still a very ongoing investigation. Our goal is to find anyone else who is involved in this heinous crime. That is the public interest, to find anybody else involved and get justice for Abby and Libby." Pages 6, line 19 through 21. Quote, "We have good reason to believe that Richard Allen is not the only person involved in this case, that there may be other actors involved. That's why we left the tip line open. That's why we left the tip email open. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible?" Pages 6, line 22, and page 7, line 2. It puts the investigation in the best position possible to determine if anyone else was involved. It is in the best interest of the public that the investigation find anyone else involved. Page 6, lines 7 and 9. 6. In addition to the prosecutor's comments, the state introduced Exhibit 1 and Exhibit 2, attached in an effort to seek an order sealing the records. The first exhibit was a letter from ISP Detective Jerry Holman, and the second exhibit was a letter from Carroll County Prosecutor's Office Investigator Steve Mullen. 7. In pertinent part, Detective Holman's letter sought the sealing of the records for many reasons, one being that the investigation is ongoing and fluid. 8. The exhibit created by Investigator Mullen cited that the matter was still being actively investigated. Investigator Mullen went on to state that law enforcement was continuing to search and seek facts and information relating to Richard Allen and other potential suspects. In this context, Investigator Mullen was concerned that the integrity of the investigation would be jeopardized if the content of the investigation documents was released to the public. 9. Richard Allen had been arrested and jailed at the time of the November 22, 2022 hearing. Yet the state acknowledged their pursuit of other suspects associated with these crimes. The state's own admissions are evidence of the existence of third-party culpability in this case, and 10. Defendant Allen requests that this court take judicial notice of the November 22, 2022 proceedings, exhibits entered during said proceeding, and ultimately deny the state's request to limit third-party evidence pursuant to paragraph 7 of the state's motion in Limine, file marked April 29, 2024. Respectfully submitted, Bradley A. Rosie. And now we have an order of judgment of the court. State of Indiana Plaintiff versus Richard M. Allen Defendant. The court, having had defendants Richard Allen's fourth Frank's motion based on newly discovered evidence and requests for hearing filed April 29, 2024, the state's response to defense's fourth motion for Frank's hearing filed May 17, 2024, and the defendant's reply to the state's response to defendant's fourth motion for Frank's hearing and request for hearing for reasons detailed herein, filed July 23, 2024, now denies same without hearing. The trial court is obligated to conduct a Frank's hearing only if the defendant makes a preliminary showing that the affiant knowingly or intentionally or with reckless disregard for the truth included a false statement in the search warrant affidavit, and that the allegedly false statement was necessary to finding of probable cause. The defense has not made such a preliminary showing, and therefore it is not entitled to a Frank's hearing. Dated August 13, 2024, signed Francis C. Gull, Special Judge. In the documents, they've included a couple of letters that were mentioned earlier in this recording. The first one from Stephen Mullen. Dear Judge Gull, I am an investigator with the Carroll County Prosecutor's Office and a lifelong resident of Carroll County. I was the Delphi Police Chief when the double homicide of Liberty German and Abigail Williams occurred. I served 24 years as a deputy with the Carroll County Sheriff's Department and was a detective with the department. I've never been involved in any investigative process as complicated and intensive as this. As the court is aware, the affidavit of arrest for Richard Allen contains information relating to the process of this investigation, witnesses, facts, and sources of those facts. This matter is still being actively investigated. We are continuing to search and seek facts and information relating to Richard Allen and other potential suspects. If the content of the documents is released at this time, the integrity of the investigation may be jeopardized. This case information, accurate or otherwise, has been widely published in traditional media and social media outlets. Release of information by the media has confused and created inaccurate tips and information. In my opinion, the release of information contained in this confidential document would only serve to complicate and frustrate the process of gathering truthful and accurate information at this time. Therefore, I respectfully ask the court to continue this confidentiality granted to the probable cause of Richard Allen for an indeterminate time, allowing investigators to complete the follow-up process. Signed, Stephen L. Mullen, Investigator, Carroll County Prosecutor's Office. And now we have a letter that was sent to Judge Gull from Jerry Holman. Also, just remind yourself that these are letters from the past. They are not current. This does not mean that the investigation is still looking for other actors, etc. Dear Honorable Judge Francis C. Gull, I'm Jerry D. Holman, a first sergeant with the Indiana State Police. After graduating the Indiana State Police Academy, I was assigned to the Lafayette District in June of 2001. I've been with the investigation for several years. I was assigned as a detective in 2006 and in 2015. I was promoted to Sergeant of Investigations. As the Investigation Squad Sergeant, I supervised the detectives' day-to-day activities. In 2016, I was promoted to First Sergeant and assigned as the District Investigative Commander. As the DIC, I review the manage all criminal investigations at the Lafayette District. I responded to Abby and Libby investigation to assist the Carroll County Sheriff's Department and continue to assist with the management of the investigation. It's my professional opinion that the probable cause affidavit could remain confidential and should remain confidential. There are many reasons for this. One reason is that the investigation is ongoing and fluid. New information comes in daily, and this information needs to be protected by keeping the probable cause confidential. This will let individuals know that they are protected and can share freely without worry of retaliation, but not releasing the information. It will protect the integrity of this investigation and everyone involved, including Mr. Allen and his family. Additionally, confidentiality will help ensure that witnesses are not harassed by the media and social media. Since this is a nationally known investigation and has been the center of so many news stories, the interest in this investigation is widespread. Many well-meaning people have numerous questions about the investigation. Due to the many questions those well-meaning people have had in the past, many false accusations and information has been put out in the public, which has caused issues for innocent people. This also causes problems for investigators with trying to investigate the facts. The media and social media outlets have posted side-by-side photos of innocent people who have adversely affected their lives. I'm concerned that they will do the same to our witnesses, Mr. Allen and their families. This could be a heavy mental burden on them to be interrogated by so many. For example, news media, bloggers, social media groups, and the general public. The physical safety of others is important to us all. We have a duty to protect everyone involved and the viability of the investigation. If we do not protect the witnesses, other potential witnesses may have a problem deciding if they will choose to cooperate. This could harm the nature of an ongoing investigation. We don't want to impede the flow of information that comes in or the safety of others. We can protect the investigation, witnesses, suspects, and all their family members by keeping the information confidential. Sincerely, Jerry D. Holman, First Sergeant, District Investigative Commander, PE 7190, Indiana State Police, District 14. And finally, another order of judgment of the court. State of Indiana, County of Carroll, State of Indiana, plaintiff versus Richard M. Allen, defendant. The court, having had Richard Allen's third Frank's notice and request for Frank's hearing based upon newly discovered evidence and request for findings of facts and conclusions of law upon any ruling on this request, filed March 13, 2024, the state's response to defense's third motion of Frank's hearing, filed April 3, 2024, and the defense reply to prosecution's response to third Frank's memorandum, filed April 5, 2024, under advisement, now denies the third request for the Frank's hearing without hearing. The court finds the affidavit submitted in support of the issuance of the search warrant contained information that a reasonable belief existed that evidence of the murders would be found in the defendant's vehicles and home. The affidavit did not contain false statements, nor did the affiant omit statutes with reckless disregard. Further, the court does not find the affiant intended to mislead the judge by failing to present relevant information. Dated August 12, 2024, signed Francis C. Gull, Special Judge, Carroll Circuit Court, Carroll County, Indiana. And there you have it. Judge Gull making some decisions today in the two Franks motions and motion in Limine, and also letters from Mullen and Holman. We'll see you next time on Deb's True Crime Notebook. Don't forget to like, subscribe, ring the bell for all notifications, share this with a friend and in your groups, and we'll see you next time. Oh, and don't forget to leave a comment. We love those comments.